questions, go ahead and raise your hand, I'll come to you.
First of all, thank you very much for coming and talking with both of you. I think this is a really critical item that needs the attention of the populace of the city, of the state of Idaho. I'm a father of 2 daughters and live here in Moscow, and it's horrifying to me, the thought that we have children in our state that are suffering and dying needlessly and without really protections. The question that I have is, this seems very intuitive, it seems very obvious, and I understand the concerns about religious freedoms and not wanting the state to overstep its bounds when it comes to how we parent. I don't want someone coming to my house and telling me how I can and cannot advise my daughters. But there are already so many laws in place that if my daughter goes to school with a bruise on her face, the government's going to intervene, and well, they should come and talk to me and say, hey, what is going on? And so I guess I would like to hear, what is the argument against changing this? I can't wrap my head around what a cogent argument would be for not protecting these children.
Well, actually, you've heard all of them, so I'll only take my own words.
I don't know if sort of coach an argument for it.
I've had this discussion for the last 3 legislative. Oops, sorry. Is it on there?
Yeah.
Okay. I have talked to legislators for the last 3 years. What I've heard, well, I'll go ahead and name his name is Senator Hyder. He was the one that said he would give us a hearing for a bill during this session, and then when the bill was presented, he refused to give it a hearing, so there was no time for it. His remark to me was, you said parental rights and religious freedom in the same sentence, and there isn't one of us that's going to jump in front of that bus. I heard from another senator that we're damned if we do and we're damned if we don't. We can't win in this situation, and how dare you bring a controversial issue like this before the legislature during an election year. Like I told him, I said, it really sucks to have to do your job, doesn't it?
I want to protect our children.
So I would just say also, I don't find this to be a very cogent argument, but it has been raised to me, and I should backtrack and say, when this first issue was first brought to my attention and I was asked my opinion on it, I kind of took the position of, you must be kidding me that there's actually a statute on the books. And then I remembered that I now live in Idaho and that there very well could be a statute like that on the book, and it did turn out to be true. And so some of the, one argument that I heard would be to get rid of the statute would actually be discriminating against religious beliefs, because it's only those with religious belief who would actually be affected. Now, I don't find that incredibly persuasive, because I think in many ways this statute actually gives a special protection based on religion, and that seems to be, like I said, to come into too much conflict with the establishment clause for my legal tastes, I should say. But that is something that an argument that has been brought to my attention. Like I said, I don't think it's cogent, but it's out there.
One thing I did bring up at the August 4th meeting, the interim committee meeting, is that almost every single coroner's report that I have, the first sentence says up front, I was called to the house of the followers of Christ for the death of a child. That's almost like that's the cause of death, or it's an excuse on why the coroners and law enforcement are not doing their job. Okay, you do not see coroner's reports that say, I was called to the house of a Mormon member, I was called to the house of an atheist member, or I was called to the home of a Catholic. These laws, the way they are written, are actually discriminating against every parent in Idaho except for parents that belong to a religious faith-healing denomination.
I'd like to commend you, Ms. Martin, for your courage to leave your faith and then just to stand up and speak for these children. I just noticed, just a point of information, there are a lot of little shippy children in this seminary. Do you know the stories behind?
There's 34 Shippey children in that cemetery that I know of. They're all related, they're not all from the same parents. In that cemetery, you'll find the same names over and over and over again. The followers do not believe in marrying outside of the church, so there are a lot of interfamily marriages. My sister-in-law is also my second cousin, so my nephew is my nephew cousin. My sister-in-law's son is, one of my sister-in-law's sons is married to my first cousin and down the line. And that brings up another issue too. Genetics are starting to kick in. So you've got a lot of children from interfamily marriages because this has been going on for generations. This church started in Idaho in 1900 in the Silver Valley of Blaine County. So when you have that many interfamily marriages, there are children that are being born with disabilities that are not getting medical care. They're not getting physical therapy. They do not have access to adaptive equipment. They are not allowed to develop to their full potential. They are not given pain medications if they're in pain. You know, what duty do these parents have when they bring a disabled child into the world? What duty do they have to that child?
And I would add to that too, again, the duty of the state. I am always struck by when I think about this issue, where on the one hand, in this context, you have the state saying to parents, we're sort of have at it, right? Gloves off, we're going to give you full autonomy and control over your live child. On the other hand, we have the state in the context of prior to birth. If there's an individual who decides that they would not like to give birth, the state has quite a few obstacles, fewer after the U.S. Supreme Court ruled this summer on an abortion case, but the court has certainly allowed the state a lot of leeway to sort of interfere and try to persuade a woman not to give birth. And in that context, the state is saying, well, we have a huge interest in preborn life, right? We have a huge, a compelling interest from the moment of conception. And yet, from the moment of birth, it seems as if the state sort of wants to take off the gloves. And I think logically, I have trouble reconciling those two positions. Is the state of Idaho's position that they have less of an interest after an individual has been born, so much so that they sort of give parents full autonomy, and yet those same parents prior to both birth are not given that same full autonomy? I personally just find that very difficult to reconcile. And so on some level, the inconsistency within the state on that issue of, well, what is the state's duty to children, whether they're born or unborn? What is their duty, and what is the scope of that parental right seems to come into play when the state wants it to, or when a parent is engaged in behavior the state likes versus when the parent is engaging in behavior the state doesn't like. And again, I think that that creates clear Establishment Clause issues. I think it also creates some clear free exercise clause issues. And I think that there are other implications about expression and choice and freedom of consciousness, most of all, that are implicated by the state having these very inconsistent approaches to its duty to protect children.
So you mentioned in the case of a minor who wants to have an abortion that there's a safety valve there, and you said that might be a possible solution for this. And so, like, I can see how with the case of abortion, it's going to be children on the older half of the age range, usually with more agency. But how would that work for, I mean, we're talking about children here who are at the very youngest end of this age range who obviously don't have the agency to start a court case, who would, I guess just from a procedural standpoint, who would be bringing these cases to the attention of the governor?
Well, already in most states, and including Idaho, when it comes to sort of child parental rights issues, you have what a guardian can be appointed to that child. So in a typical case, one or more parents are sort of under investigation for some type of violation of their duty to protect their child. That person gets an attorney, right? But the child also gets someone who's appointed, whether it's a guardian or some type of attorney, and their sole job is to look out for the best interest of that child. So I think in the same way that we see children have some type of representative in the context of abortion, parental termination, I think that it is quite possible to adapt those procedures for this particular circumstance. Now, in my mind, clearly as that child ages, right, that child's views should be taken more into account. I don't have children, but there's very little I would listen to a 4-year-old on. And so in that case, it may be, and I would suspect that a parent has more authority the younger the child is. But as you said, once that child sort of creeps towards adolescence and teenage years, then clearly that child's, the authority will grow for the child and shrink for the parent. So I think you can just appoint an independent guardian whose job it is to sort of look out for the best interest of the child. Now, one last thing, I think as a child is younger, I think there should be a very strong presumption in favor of the parents, just due to that child's age. But again, I think the threshold question should be what is in the best interest of that child.
I think that maybe one of the arguments made against repealing this action may be that those in favor of it believe that neglect is not it's a non-issue essentially, where these parents are obviously looking out for the kid's best interest, where this isn't really a problem, and so the government shouldn't be stepping in and setting a finish up for the child. I think there might be some success in repealing this action if it were attacked in two parts, where the first part would be the enforcement of the coroner's report and an accurate autopsy, saying that getting some information and saying, as we suspect, that yes, this neglect is an issue, these deaths are preventable, this does create a problem. And in that case, we might have better, more influence on legislators in repealing this and saying, yeah, we do need to do this.
The governor's task force on children at risk and the child fatality review team is made up of experts. There's doctors, there's child protection people. There's people from every walk of life on that task force. For 2 years in a row, they have asked the governor and the legislature to look into changing these laws because it is a problem. They said that the children are at risk and they do need to be protected. So you've got an agency that's actually been appointed by the governor to advise him and to advise the legislature, and they're ignoring